Welcome to SpringLaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
Hello everyone, and welcome to our SpringLaw monthly employment law webinar. My name is Stam, and joining me today is my colleague Phil Szadurski, an employment lawyer here on our team. Thanks for joining us this month. We're going to be talking about dependent contractors and talk about the employer obligations and legal risks around that. For those of you who are new to our webinars, we are a Canadian virtual law employment law firm specializing in employment and contracts law. The platform, for those who have been attending our webinars for a while, you'll notice some differences. The platform has had a bit of an update, so feel free to still ask questions through the chat. It might take you a moment to figure out where that is. You can download the slide deck from there as well. And then if we don't get to your questions, just follow up with us afterwards. If you'd like any more resources on employment law, join us at springlaw.ca, where we have our award-winning weekly blog posts, a link to subscribe to our monthly newsletter, and then just general information on our subscription program, which we have for employers, as well as some DIY innovative legal products. Okay, let's get started. Phil, welcome.
Thanks, everyone. And Lisa, thanks for having me. This is my second webinar that I've been able to co-host, and it's a real joy of my practice to be able to do these. I love these topics, so I'm really looking forward to today's webinar.
Awesome. And yeah, and both Phil and I have had lots of messy situations where is a person a contractor, an independent contractor, or that gray, messy area that we're going to talk about today, or an employee is the other end of that spectrum. Okay, but first and foremost, we want to acknowledge that the land on which we operate is the traditional territory of the Anishinaabe, the Haudenosaunee, the Huron-Wendat, and the peoples of the Mississauga Credit First Nation, who have stewarded these lands for generations. We recognize that Indigenous people lived and thrived here long before the arrival of settlers, and we acknowledge the lasting impact of colonialism. As part of our commitment to truth and reconciliation, we strive to learn, unlearn, and understand the history and effects of these wrongs, and we are grateful to live and work on this land. And of course, we should acknowledge that this is the land on which our office is, but we are a remote law firm, and all of our lawyers are around the province, and so our land acknowledgement expands beyond these areas, of course. As any regular listener knows, this is all legal information, not legal advice. So please keep that in mind. Here's the fine print about how this is all just legal information. Okay, now that no one's read that, but hopefully you all get the point. Let's talk about our presentation roadmap for the day. So we're going to talk about the status of your workers, why mischaracterization really matters. We're going to look at some case studies, and Phil's going to talk about some of the, what the case law is saying, so that you get some examples of this weird gray area that is increasingly higher risk for employers. And then we'll try and get practical about how to, some practical tips about getting it all right. So that is our roadmap for today. If you are an employer that does not knowingly have dependent contractors, this still is an important topic to discuss, because we're going to also really sort through that contractor versus employee relationship. So even if you're someone, a workplace that doesn't really have dependent contractors, this is still, I hope, will be a useful conversation about how to really tease out those nuances between those relationships. Okay, Phil, over to you.
Thanks, Lisa, and thanks, everyone. So, feeding off what Lisa was saying, this presentation is specifically about dependent contractors for the most part, but it is really a subset of this larger conversation of, do I have an employee? Do I have an independent contractor? What's the difference? What are the responsibilities? And what are the liabilities that come with all of these relationships, right? So to begin this, what is an employee, right? An employee works with the business, under the business's control, where the employer dictates basically everything, right? How, when, and where work is performed, right? The employer pays the income taxes, right? And the employee is entitled to all sorts of benefits, right? So EI, CPP, vacation, and termination pay, right? And many more beyond that, breaks, right? Like everything that we all know as the standard employee-employer relationship. And you'll see a theme throughout this presentation of, are these present or are they not, is definitely part of this conversation. So what is an independent contractor? A true independent contractor basically just runs their own business. The most clear example is someone's selling a product, someone's buying a product, right? Like let's say SpringLaw purchases a product from another company. That is a business on business relationship, and an independent contractor relationship should mirror that as much as absolutely possible, right? So an independent contractor controls their own work, controls their schedule and tools within the reasonable feasibility of a business, right? So a true independent contractor has control all of these things, but there is some ability for the employer of the independent contractor to say, well, this is the product we need, this is when we need it, and this is the quality of the product that we require, right? So they're not in absolute control of everything, but they basically have the control for the most part of their schedule, availability, and how many people work on the project and those sort of things. So unlike an employee, there's no EI. An independent contractor can pay their own EI, right? Like even someone that owns their own business can pay their own EI, but the employer doesn't deduct that. No CPP, no vacation, no termination entitlements, none of that, right? And the worker charges HST on their services. We'll talk about a little bit more of substance versus form, but a lot of employers will come to us and say, well, they charge HST and give us an invoice for HST. They're not an employee, right? It's one of the most common things we see. It's like, well, no, they have a business and they charge us HST, therefore they're not, right? And it's one of the biggest areas of conflict that comes up when an employer realizes that that is merely one factor and not determinant of the relationship, right? So, all right, and moving on to what a dependent contractor is. This is where it gets fun. Well, for us, right?
Yeah, not for workplaces.
Not for all the employers, but this is where the employment law nerdiness comes in, and we enjoy the discussions back and forth about is what's the dependent contractor trap, right? Are they fully independent, or are they employee, or is it something in between, right? So a dependent contractor, by definition, is someone that is an independent contractor at law. That's fine, but they're economically dependent for the most part on one client, right? That's the key determination. If you were to take anything away from this presentation, not advice, information, of course, it would be that a dependent contractor is a contractor, but almost entirely dependent on one client for the majority of their income, right? And then what happens as a result of that, Lisa will talk a little bit more about, but it basically means that upon termination, they have to be treated like an employee, right? And then that's where the liability, for the most part, stems.
Mm-hmm.
And I think it's over to you now, Lisa.
I think you have one more slide.
Do I have one more slide?
Yeah.
Oh, yeah. My apologies. So employee versus contractor, the key factors is really, this is before the dependent contractor analysis, right? So as I said, a dependent contractor is an independent contractor that's already been established at law, but then they are dependent. So first you must establish, are they an employee or an independent contractor? And an independent contractor versus an employee, you really have to look at control, integration, tools and expenses. Are they a key employee, or are they just on the peripheries, right? There are actually about 5 or 6 different legal tests created by the case law for the independent contractor versus employee relationship. And it's an employment lawyer's job to find which test is most applicable to the facts of the case, right? So there's the integration test, there's the control test. The control test is one of the most popular and the most prevalent one you'll see. But some of the indicators of an employee versus an independent contractor are, like was stated before, the employer controls work schedule, product, when, how, and where. A big one is who provides the hardware, right? Whether it's computers or tools for the job. Do they wear emblems? So in the manufacturing or the construction trade, there's a big set of case law that says, well, you're making this quote unquote independent contractor wear your company's emblem on their truck or on their hat or on their tools, right? So are they truly an independent contractor? And that's a whole discussion as well. So many tests all can be summed up by control, integration, and in substance, what is the relation designed to be?
Right. Okay. So let's move on to why characterization matters. But before we do that, we're going to run a quick poll. I'm curious for the attendees, if you are mostly employees, mostly independent contractors, a bit of both, or have no. Okay, we have too many people with no idea, so that is it's good to know, and that is the big danger. Okay, good, it's coming down. One jumped in there and skewed the numbers.
Yeah.
Okay, so it is a mix and a bit of both, and so yeah, there's that gray area in the middle. Employees, okay. I mean, the courts love it when you just call someone an employee because that gives them the greatest rights. So for the 69% of the people with mostly employees, that's probably a safe end to be with all of this. Okay. You can see, Phil, on your end, right? The results as
I can see this is great. Mostly employees and a little bit of gray area, and I have no ideas. Well, we're glad you're here, and we'll chat more about it.
Excellent. Okay, so let's go back to why mischaracterization matters. So basically, you can't fake it. The courts are going to look at the actual relationship. They're not going to look at the job title so much. I mean, they'll look at it, but it's what will be really the most important is they're going to look under the hood and look at the substance of the actual role. So why it matters, Phil already talked through the why the mischaracterization can really matter. Termination and taxes. I would say those are the two big reasons why this matters. So if you mischaracterize someone as an independent contractor, the courts have this legal assumption that there is a balance of power between the parties, and so they are more likely to defer to the terms of a contract for an independent contractor relationship, regardless of whether or not it's a great deal for the worker. Whereas in an employment relationship, the courts always see the employee as a vulnerable party in that situation. Any tie goes to the employee. Any ambiguity, there's this deference to protecting the employee in that relationship, and that is a fundamental difference between this employee way over here and then contractor on the spectrum over here. So that's number one. That's why it matters if you mischaracterize the relationships, because of how the courts are going to look at this, the case law, and then very little goes to trial, so that's not what we're worried about. It's the legal entitlements that an employee is going to give assert up front. The other big one is taxes. We are not tax lawyers, so I'm not going to give any tax advice here. We actually had a tax lawyer on as a guest a year ago, March of last year, and she really talked through all of these relationships. So feel free to go onto our YouTube channel and take a look at that if you're worried about the tax piece. If you mischaracterize an independent contractor, if you mischaracterize a worker and they're actually an independent contractor, they're the ones that are on the hook. They're the ones that should have been remitting HST all this time. As soon as they make, usually it's over 30 grand, they are supposed to be giving you their HST number and remitting tax on their own as basically a business owner. If they fail to do so, it's that contractor who's liable to CRA, to the Canada Revenue Agency, not the employer. If it's an employee and we've mischaracterized a contractor and they're actually an employee, then the employer is really up the creek. You should have been deducting income tax and remitting that on the employee's behalf. and all their CPP and EI entitlements. So that's a whole bunch of liability to the CRA that will kick in. Now, the big kicker here is that it is free and easy for any worker to click a button on the CRA website when they're filing their own taxes, or a free phone call to the Ministry of Labor to trigger an investigation or an assessment of, are they an employee or a contractor? So it's why this is actually a really high risk area, because it's so easy to get in trouble about it, because the employee doesn't need to go through a great big piece of litigation. All they need to do is click that button and ask, am I an employee or a contractor? And then the CRA is very happy to have people be assessed and characterized as an employee, because that's more taxes, right? And it's a part of this overall concept in Canadian law of the vulnerable worker, and really always doing what you can to help the vulnerable worker, in that case, the taxpayer. So this is why, it does matter around how you characterize everyone. Now, what about dependent contractors? So they do have this employee-like rights, and it's an area that I would say has really picked up steam over the last 10 years or so. I feel like at one point, really we had two main buckets, and nobody really talked about dependent contractors. But as you know, we have an increasingly litigious universe. The courts are being asked to really assess these in-between gray area relationships. So fundamentally, if it smells like an employee, courts are probably going to find that this person is an employee. They're going to look at a lot of these criteria that Phil already went through, the control, the exclusivity, it's a similar, not identical, but a similar checklist to what you would look at if you're trying to figure out if someone's an independent contractor. Basically, how much are they embedded in your organization? How much are they required to comply with all of your procedures and rules and hours, and really having them behave as an employee. But exclusivity is the big one. And Phil's going to go through some case law in a bit around all of this. So if they have employee-like rights and it smells like an employee, it's not so much about statutory rights, because this is not an ESA statutory thing. This is a common law thing. So it's not necessarily about whether or not we're breaching the ESA. It's about whether or not this person has common law entitlements. Now that will include, the rights to I shouldn't say that you don't have to comply with the ESA. That's not at all what I'm saying. I'm saying this dependent contractor universe comes out of case law. The ESA is silent on this. And so this is why, if you haven't heard of this, this is why it's an issue. If you are a unionized workplace, dependent contractors are expressly included within the definition of employee in the Labor Relations Act. So it takes care of itself fairly automatically in the unionized workplace. But in the non-unionized workplaces, it really is all going to turn on facts. And it's, how much are they in the middle of the spectrum of just really smelling like an employee? And then that's where you start to get, what spills out of that is the tax and ESA obligations. We had a question from Annie ahead of time, one of our regular attendees, and so I love that she took the time to send in a question ahead of time. So we wanted to address it in the context of the session. So Annie, I hope you're on. I can't see the list while I'm talking, but hopefully you're on. But this question I thought had really wide application. In post-COVID, we see so many workplaces with increasingly remote workers and an increasingly an increasingly global workplace as well. So the question that Annie asked is, what happens to your international contractors? Are there any key differences compared to local contractors, and whether or not there's any additional risks or guidelines? So does location of worker impact your worker status? So first of all, if they're a seconded employee that you're pushing out to another division, another branch in another country, that is a whole specific area of law that I'm not going to talk about. It's a whole thing, right? Lots of tax and treaty implications of that. So that's a different thing altogether. Usually there's some contracts that you need to have in place on top of their regular underlying local contract, and it's a whole thing. So, but that I don't think is what the question's about, but I'm just sort of knocking that off the list. It's seconded employees in a global organization is like its own little bucket. And they're probably still an employee that's moving around. But if they are a contractor working in, for a lot of Canadian organizations, we have workers in California, for example, and what does that all look like? So location itself will not necessarily automatically dictate the characterization of any relationship. It still is going to come back to what's actually going on. You can have employees in other jurisdictions, but it is super complicated from a tax point of view, from an international treaty point of view, from a corporate law where you might be establishing a corporate entity in that other jurisdiction inadvertently because you have one contractor who's actually an employee in that organization or in that jurisdiction. Again, take a look at the full webinar we did a year ago on all of this. It's quite complex, and tax is really what drives the biggest worries of that area, not so much employment law. So yes, you can have employees in other areas, but really what's going to happen are in other jurisdictions. But that assessment of whether they're an employee or independent contractor, it's still going to be the same factors, control, all of that kind of stuff. So you can have an employee elsewhere. But this is just a great big warning that, unless you've gotten a lot of comprehensive legal advice, you'll want to be careful about that. And so really do what you can to make the person an independent contractor. And that's where you get that checklist of, control and tools and exclusivity, making them non-exclusive, all that kind of stuff to make sure that they fall more in that independent contractor bucket, unless you've really sought out the comprehensive advice. Now, what about company provided devices? So I loved this question because we see this more and more where it's a data security question, right? You have people working all around the world. It's a data security, and it's like a workflow for your organization, having everyone, have access to the same tech stack and tools to do, to service your customers or clients. And so providing a laptop, for example, to someone. Laptops are cheap these days, big picture, so it's not a unusual tool to provide. So does this impact the characterization? You're now providing the tool for someone to do their primary tool in the knowledge industry, and so are you now swinging them closer to employee status? Possibly, but again, it's one of many factors that would be part of all this. So tools is not the defining, exclusivity, and there's a couple of other factors that probably have higher weight, but the tools is not the highest weight. The bottom line here is that companies will really want to balance their risks on this. On the one hand, you do inch towards employee status if you start providing a laptop and tools. On the other hand, it could be that your organization's data security risks are far more of a liability for you than employment law. Your worst case scenario in employment law situation is that you've mischaracterized an employee and now you have some tax and termination pay obligations to that person or liabilities that you might face. But in a worst case situation with a major data breach or IP theft, that can shut your company down. So it's a balancing risk situation about how much you're going to provide a tool to an international contractor, and so the risks here is less about the characterization in my view, and it's more about thinking especially about the data security, if that's a big reason why you're providing the tools. So I hope that answers the question and it wasn't too much of a tangent, but if people do have questions ahead of time, we want to reward you with the legal information that we are providing on this webinar. All right, Phil, over to you to talk about some cases.
Awesome. Case law, my favorite and everyone's worst nightmare, and that's okay. So today I want to talk about 3 cases, and it's kind of like, I'm not going to go into a history lesson, but these 3 cases help identify exactly how to identify a dependent contractor to your best ability and what to do if that happens, right? So the first case is, I just call McKee. This one in 2009 from the Court of Appeal of Ontario, also known as Supreme Court of Canada #2, right? Because they tend to just set the stage for the whole country a lot of the time. This case set the stage and solidified the concept of the dependent contractor. Before then, it was like talked about a little bit, but really wasn't solidified. And it identified the initial test, and I talked about that a little bit. First, you have to assess, is a person, a worker, an employee, or an independent contractor? Then once you make that assessment, and this is the assessment a court will take, if there's a dispute, because these disputes happen all the time, right? They'll say, are they employee or independent contractor? And then once you've identified if they are a true independent contractor, are they a dependent contractor based on exclusivity, amongst other factors, but primarily exclusivity? So that case was the first one to really hash out what it is and how do we identify it, right? And that kind of sets the stage for the next two cases. And I'll go into the next case now. So the second one is Keenan and Connect Kitchens. So it provided the exclusivity analysis, right? Because the courts have a tendency of saying, okay, McKee said, once they're an independent contractor, are they exclusive? But they didn't do a great job of explaining what exclusive means, right? So in Keenan, they identified that employers or the company contracting a contractor, whatever they want to call themselves, right? When arguing that someone's a contractor, they need to put forward the whole history of the relationship with this individual, right? They can't just pull out and say, in 2024, this is how much they made, this was the relationship, this was their schedule, these are some emails showing that they had control, right? Ignoring, 2010 to 2023, where the relationship was much different and evolved a little bit, right? So you really have to take the whole relationship into account and assess what the relationship in substance was designed to be, right? So they clearly identified that it cannot be a snapshot in time, right? And exclusivity, they went further to talk about exclusivity, and they really focused on economic dependence, right? So the argument will always be from the employer side, right? Well, they had 3 clients, right? I was just 25% of their business, right? In that case, more likely to be an independent contractor than a dependent contractor because they made money elsewhere and their mortgage payments, food payments, everything wasn't dependent on one client, right? So economic dependence really came out of this case as the driving factor to establish exclusivity. And then I have one more case to discuss, and a lot of employment lawyers say this is the most helpful case, but I see this case as it has evolved since then as helpful, but also very dangerous. And it depends on how advice is given in relation to this case. This case was super helpful and involved someone who was identified as an independent contractor by the courts. And I think at the end of the day, they did the math and her income was 34% her income from the children's lawyer, Ontario, was 34% of her cumulative income annually, right? So they decided, well, it's not at least 50%, therefore she's not economically independent, therefore she's not exclusive, and therefore she's an independent contractor, right? And from that helpful analysis came the idea that if they're less than 50% dependent, it equals independent contractor, right? Which often will be true, but it's not necessarily correct, right? And that has to do with many factors, including that historical analysis, right? Well, when was this employee 38%, or sorry, when was this contractor 38% reliant, right? When the year before, were they 56%? Were they 78%? And how many years and holistically are we looking at, right? And then we take the whole number into account. And is it over 51%? Yes. Then a court decides whether they're exclusive or not. Does that mean that if you get to the 49% mark, will a court say not exclusive? It's up to the court. It's up to the judge that day. It's up to how they're feeling. It's up to the rest of the facts, right? So this case, very helpful, but it does not mean that 50% less than 50% equals true independent contractor, right? So there is still nuance to the assessment, but it is a helpful guiding tool to establish which one it is. Absolutely.
And as a firm, as individual lawyers, we try so hard not to say it depends. That's
Yeah.
annoying to hear as a client.
Yeah.
It's unhelpful when you're trying to solve problems as a business owner. I totally get it.
Mhm.
But this is an area where it really does depend on,
Yeah.
especially the facts, right? And this is why we started out. You can't fake it. It's sort of,
Yeah.
it is what it is in terms of how people are organized in your workplace.
And the court's really at the end of the day trying to figure out, are you trying to skirt the employment
Yes.
law responsibilities by
Mhm.
hiring this person an independent contractor? And we represent employees and employers, and many times employers are just trying to figure out a way to structure their business in a way where they use independent contractors to, I wouldn't say avoid responsibilities, but to streamline their business and mitigate cost, right,
Mhm.
to their business, which is totally normal. But if a court decides that that process and business model is trying to skirt employment, tax, vacation, minimum entitlement liabilities, they're going to go with the employee analysis more likely. So my
Yeah,
last
that's a
slide.
good point.
Yeah, thank you. Yeah, so it's really a substance over form issue. It really is, and that's kind of a guiding theme with courts in general when it comes to employment law. My
Mhm.
last slide here is just to further kind of touch on that it is a nuanced area. I'm not going to say it depends, but I'm going to say that there is nuances in the economic dependence analysis. Even then, going back to the control test may trump economic dependence test, right? So you really have to assess the facts. For example, there is case law out there to support, and we just didn't bring it forward today because it really gets into the weeds and it gets too far into it. That uh, if I think there was one case that said this person was 74% economically dependent, but every other aspect of their business, the logos, the invoicing, the control, everything like that, sided with an independent contractor analysis. Everything except for economic dependence, and the court sided with independent contractor, right? That's not to say that the economic dependence test again doesn't matter and the 50% line doesn't matter, but it does matter that the assessment is based on the facts, and really bringing forward all the information could be quite helpful for a lawyer to assess the chances of the decision going one way or another.
Yeah. Um, Before we jump into this next section, which will be sort of practical tips, we have a bunch of questions coming in. So why don't we go through a few questions sort of midway and see where we get. So I'll start reading out some questions and you can take it or leave it, Phil. We can arm wrestle about who's going to answer. So question number 1 from Sally. Is it possible to have a contractor brought on as a fractional leader of the company, a CMO or a CTO, to help lead that respective function and have that team report to them while the company searches for their full-time permanent hire for the role without risking misclassification for the contractor in that fractional capacity? Awesome question, because this happens all the time.
Great question. Do you want to take this one, Lisa, or do you want me?
No, go ahead. If you're nodding as if you're really chomping at the bit, go for it.
It's a great question. We get it all the time. We get it a lot with U.S. employers who do business in Canada, right? They want to hire someone to be the CFO or to be an HR manager, especially when they're establishing an entity here, right? And they ask if we can do it on a part-time or fractional basis. It's an interesting question because it collides different tests together, right? So you have the integration test, is this a key employee, competing with the fractional and economic dependence test, right? So I'll answer it this way. If this CFO or CEO has 4 other identical roles and clearly chooses to be an independent contractor and offer their services this way and has there for a long time, and the relationship between them is very clearly established that sides in the favor of independent contractor relationship and not a dependent contractor relationship or an employee, because they have other jobs that they're doing it for. However, the fact that they're this key employee, if it lasts too long, right? And they really turn into this employee that, you're looking and looking and looking and looking for this permanent individual, and it starts going into 2 years or
Yes.
8 months or a year and a half, right? Then the misclassification becomes a risk, especially if they're like, okay, I'm gonna either with you knowing or not knowing, one of their clients drops off because they finished the job. Then another client drops off because they finished the job, right? And all of a sudden they're 45%, then they're 55%, and they're taking on responsibility, right? That's where it gets tricky, and that's what often happens, is that these lines melt together and become that gray area that we know so well.
I think one practical way to help really lessen the risk here is if it's truly a project and there's a clear finish and end to the thing, then it's going to be really hard for someone to argue that that's long-term employment. And so to the extent that you can make this fractional, CMO or CFO role, make it clear that this is a temporary project to assist with this thing that's going to clearly end when this thing happens. And so I certainly agree with Phil that if that thing doesn't happen for 10 years, you're in big trouble. But typically if it's a project where they come in and they help roll out, let's say you're migrating to a new platform, or, these projects that might be 4, 5, 8, 10, 12 months. But if it's defined, that will really, really help. And that person, by definition, probably is heavily integrated, but they're really flying in as an expert to help do this thing. And then they leave again and they go do that thing with a competitor next. And that will, that makes it all very clearly not an employment relationship.
And if you do the fractional approach and you end up extending the fractional pieces, then just make sure you get advice on how to extend it properly, because that brings forward another area of entirely of employment law, of fixed term contracts turning into indefinite employment. So which we won't get into today, but that's incredibly helpful. Absolutely, fixed terms in those circumstances are very helpful if implemented properly, for sure.
Yeah. Christine has asked a question. If you have an independent contractor and you put them on your benefits plan where they are paying for the full premium themselves, would they be considered an employee or a dependent contractor? Go ahead, Phil. What do you think?
Oh, you want me to take this one? Sure. So the benefit, I had a big case involved with this, and the opposing side, I was on for the employer, and one of their main arguments was, well, she was on the benefits plan, right? So she's an employee, right? You can't. In that case, they put themselves on the benefits plan without the permission of the employer, but that's a whole other that's a whole other ball game. But in these circumstances, it wouldn't even be so much the line between independent contractor and dependent contractor that would affect. It would affect the first part of the test, the employee versus independent contractor test, right? So putting someone on the benefits, whether they pay for themselves or not, is a shot towards employee. If they chose to go on them, they pay it, and everything else leans itself into the independent contractor analysis. It likely wouldn't be a silver bullet, but it is fact dependent on, are there any other factors that lead to the independent contractor versus employee test first. But definitely on its own, without context, putting someone on benefits is a hard check mark in the employee.
And if it includes LTD, that especially is tricky, because LTD by definition is there's case law that speaks to this. It's intended to be, the parties are intending up front that the employer is going to take care of that employee through this benefit program if they get sick on a long-term permanent basis. So LTD is especially tricky. If the contractor is paying their own group benefits so their kids can get a bit of dental, and especially if it happens to be on a project basis, maybe, but that's probably not at all what's going on. It really is probably this longer term contractor. I agree that is tricky, and I'm guessing what will happen is it'll start to spill over into exclusivity and how much this person's economic dependence is turning on you as the workplace in that contract with the contractor. I think putting them on benefits is high risk for sure.
Yeah. And I forgot one important aspect of that. Many benefits providers will only put them under the employer's benefits if they are an employee proper.
Exactly.
So if that's the case, you have to look at the policy. Is it permitted to allow independent contractors? Often not. And then if they are labeled employee proper under the insurance plan, that's a problem for sure.
Yeah. Both potential insurance fraud, but also just
Yes,
all the
yes,
headaches that termination
yes,
of
yeah,
whether or not they're what they're
yeah,
entitled to.
absolutely.
Angelica has a question. I'm aware of a company that is charging HST to an independent contractor on top of their hourly wage. Now, I don't know, Angelica, if you're using wage deliberately there. If it's an hourly fee or an hourly rate, and they charge HST on top of that, that's okay. If the HST is on top of a wage and they're getting a pay statement and it's and it is wages, then we're commingling way too many things. The right way to do this invoicing is that the contractor, to keep them in a proper independent contractor category, is that they should be issuing invoices to the company, whatever it is. It can be on a recurring basis, weekly, bi-weekly, monthly, that's fine. But there should be a list of the services or goods that they're providing and the HST that that is being charged on that. And so I'm guessing wage is not the meaning intended here. If it's an hourly rate or hourly fee, then yes, HST, I think it's actually really helpful to everybody to have HST charged on top of that in order to make it super clear what's going on, that this is absolutely an independent contractor relationship. I have had a case a few years ago now where that no HST was being gathered. So it was like a really big headache when the contractor asked CRA for an assessment, and it was one of these clinics with chiropractors and physiotherapists and a whole bunch of different types of health care services that have also medical HST differences. And then, but if you're like doing some sort of non-medical physiotherapy in there, then it's a different HST. So the tax gets really bonkers in these clinics. But you can't have it an hourly rate and then we all forget to charge HST and then after argue, oh no, it was the rate inclusive of HST. That won't fly. I can tell you that right now. It just won't fly. So definitely charge on top of the hourly rate. Anything to add to that, Phil?
No, that's perfect. The distinction between wage and how you charge it is important, and how you charge is important in every area of employment law, including vacation on bonuses and stuff, which we won't even get into, but it's the same theme all around. Has to be shown and separate.
Yeah, exactly. Yeah. We'll do another way. It's 11:12. We can do a few more. So Shelby has a question. Is it okay for an independent contractor to have access to internal communication tools like Slack or Teams? Can they attend department meetings? What about a business work email? Business card? This would also include things like business cards. I would also include in this, how are they communicating to the world on LinkedIn, for example? Are they on the website? How are they being presented to the world? And then how are they communicating? So that's two different questions. How are they communicating internally, if at all? And then how are they being presented to the world? Go ahead, Phil.
You want me to get that one? Yeah, sure. It's, again, substance over form, right? No, I'm not going to say it. I'm not going to say the D word. I'm going to say substance over form. Okay. So what is the relationship intended to be, right? Yes, absolutely. Integrating them into the fold, as we'll call it, is check mark in the employee bucket, right? But it's on the other side of the argument, it's almost impossible to run a business with an independent contractor without giving them access to your internal servers and all of this kind of stuff. So that aspect alone won't dictate it, right? Unless that access makes them a key employee. For example, you give them elevated access to payroll, to, for example, calendar, can see everything, change everything, right? Like that level of that will matter, right? But simply giving them access to your internal mechanisms so you can function as a business and they can assist in that functioning wouldn't be a determinant. Now, going to holiday parties, all of this other stuff is a
Mm-hmm.
factor that will be assessed, right? It's not determinate, right? If you have a policy and a historical application of that policy that everyone gets treated, independent contractor or employee or not, gets treated in a family manner, and we want people to be there because they're a part of the business and they help the business succeed, that's
Mm-hmm.
good, and that's for you, right? But it does blur the lines. And again, this is part of the employee versus independent contractor analysis. This isn't part so much of the dependent contractor analysis. It's really, are they an employee? Are they an independent contractor, right? And
Mm-hmm.
yes, integrating them into the fold will be something that be seen as more indicative of an employee. Must be assessed within all of the facts, substance over form. What is the relationship intended to be? And over time, what I have seen in my experience is that when employers try to do something nice and include people in all
Yes.
aspects of their business, they get punished because they get hit
Yeah.
with misclassification at the end. Does that mean you should stop doing it? Does that mean that it's every time you're going to get punished? No, but it tends to go that way because when you have those policies, the integration over time becomes more and more and more and more solidified, right? And
Yeah.
once those lines are blurred to the point where on a balance of probabilities, a court's going to say it looks more like an employee than an independent contractor, they're going to decide in favor of the employee because, like Lisa said, it's all about protecting the employee.
Yeah, it is that integration piece for sure. In the world of tech, I anticipate that we'll keep evolving on this because, providing an employee with access to your Slack teams, like our bookkeeper has access to our finance section of our Google Slack channels, or Google channels. It doesn't mean that they're an employee. It really is a modern way that people use technology. So I anticipate that will start to subside a little bit. I think it's this integration piece, and how are they being presented to the world, right? So are they on your website as and are you referencing them as an employee in your communications externally? Are they on your, I don't know, advertisements about the services you provide as one of your key service providers without distinguishing, or, but with that full integration? I think that's going to be a big problem.
Absolutely.
We have a question from Monty. And this is a good, just to clarify, I think he's waiting, like, tell us about the dependent contractor status. So what is the significance of the dependent contractor status? Is it only about termination notice, or does it also create Revenue Canada liability? So thank you. Maybe we've been too excited to talk about IC versus employee without, and this gray area in the middle. The big picture issue here is that it really pushes these entitlements over to looking like an employee. So it does include the termination exposure of termination pay, but does it have a CRA liability?
Yeah, if you are found to misclassify someone, right? Or the dependent contractor piece specifically, you mean?
Yeah, so if the courts, if the
less,
common law says it's a dependent
yeah,
contractor,
yeah.
they'll say you, employer, should have given them termination
Mhm.
pay. But what about income tax, CPP, and EI?
So from my understanding, and the case law is constantly evolving on this, the dependent contractor is still a contractor, right? And if the employer has handled their requirements under the CRA of paying a contractor, charging HST, remitting HST, and all that kind of stuff, they should be okay, right? It becomes more of a concern if they're leaning towards employee, right? Having said that, I foresee, I love when, like Lisa projected in 10 years, right? What the tech sphere is going to look like. I foresee this line between dependent contractor and employee long term, because where the courts do it, is going to become even more aligned or misaligned or gray. and the courts are really going to start treating them more just like employees in general. And what's going to happen as a result of that? We don't have the regulations or the legislation in place to really assess that. But my usual advice is, if you're complying with your tax requirements, and not a tax lawyer, right? Like, again, if you're complying with your tax requirements, whether for an employee or a contractor properly, then you should be okay, even if someone's a dependent contractor, right? Versus an independent contractor. But if you really want a hard answer, an accountant or a tax counsel would be a better person to ask from that piece, for sure.
It's why one of the cases that Phil was talking about earlier, it talks about those two steps. The first step is, is this an employee or a contractor, independent contractor? And so we need to, in order to even get to a dependent contractor status, we need to find that they're actually an independent contractor, but they smell too much like an employee. And I know that's like very circular, but they are ultimately still in this big picture bucket of a dependent contractor. It's just that the common law is now providing things like termination pay. And it's why I also had mentioned it's not pure statutory entitlements. This is a common law. This is a creature of the courts. It's not a creature of the Employment Standards Act. And so that's why it's the first step is, are they a contractor in form? But then are there too many things that are making them entitled to a longer notice? That's going to be the core output of this. But it's that slippery slope, though, right, Phil? Because then it's like, well, okay, they get notice, but then how come you're doing all these other things? And both the Ministry of Labor and CRA are happy to do an assessment and see maybe they actually are all employees.
Yeah. And this is where I rack my brain all the time. Is like, well, if they're a dependent contractor, what notice are they entitled to? And is the termination clause in their independent contractor agreement good enough, right? And the only answer we have to that is no one really knows, because the courts have decided a million different things. So I won't waste everyone's time on that. But it's when the termination clause in the independent contractor agreement, if it's 14 days, a court is likely going to say that's not good enough for a dependent contractor. But if it's 6 months, it might be good enough. Right. And if they've been around for 20 years, that 6 months is a lot better than 24. Right. So that's where a real good conversation with counsel is highly suggested, for sure.
Yeah, exactly. We have only a few minutes left, so I'm just going to do one more quick question. It's an easy, quick question, and then we can move into the practical getting it right steps. This is from Tim asking, what about contractors who request on their own, of their own volition, to be an independent contractor, but they're 50% plus and scheduled? So the quick answer here is, it doesn't matter what the parties want. It's what are the parties doing? Right. And so we often will see this, where the employer's argument to us is, but the employee asked for this. They want, because everyone thinks, ooh, I don't have to pay so much tax all of a sudden. It's a different tax rate. It just feels like, and then you can write off your car, and you can do this and you can do that. But so it could be that both the employer and the contractor want this relationship. Nobody cares. Well, they care, we care. The courts don't care, the CRA doesn't care, and the Ministry of Labor doesn't care. It's going to be what is actually happening here is what they're going to look at. Intention of the parties doesn't matter, which is a little bit frustrating, but it is what it is in this case. Okay, let me, there was a bunch of other questions, and I love that we're getting a bunch, and I'm sorry we haven't gotten to all of them. If they're, certainly if there's bigger questions, reach out to us afterwards, but hopefully we'll cover it a little bit in the final slides here. So how to get the classification right? First of all, use a legal test. Don't use, don't rely on just you putting words in the contract and trying to reflect the intention of the parties. And I know that sounds very counterintuitive, because that's how law ought to work, but it's understand the legal tests, and if you're not sure, get some legal advice. Make sure that your contracts are right, that they're reflecting what's actually going on, not just aspirationally what we want. Another piece around this is train your managers as well. Make sure that the people who are integrating or overseeing an independent contractor understand the limits that they may have, right? So sometimes the liability is flowing from people on your team who don't understand the legal nuances here. So if you have a enthusiastic manager who's enforcing hours of work and controlling the how the work is done, and controlling all the things, and really integrating the person and forcing them to come to meetings, and all the things that may be really undermining that contractor status, make sure that your managers have a sense of what's going on, and so that they understand there's a legal test going on here. Regularly review your contractor relationships as businesses evolve. So keep an eye on any evolving relationships. Lots of times a contractor evolves into an employment relationship. And as Phil had alluded, we often see these, one-year contractor relationships that evolve into, maybe they'll get like a renewal of one more year. And now we're into that fixed term contract mess, where things just get renewed over and over, and they become an indefinite permanent employee with all the stuff that comes out of that. So keep an eye on any evolving work relationships. And then if in doubt, seek legal advice. Proactive compliance is always cheaper than litigation. And I feel like we can say that on every single webinar that we give. But, talking to, counsel ahead of time. And then the other one is you can, and this is a buyer beware suggestion, you can always request the Canada Revenue Agency to give you an interpretation of a relationship. You can ask them to classify, to review the classification of one of your workers to know if you've got it right. Buyer beware, like sometimes that's a dangerous thing to do. Sometimes it's a really excellent, helpful thing to do. So that's your organization's, if you have one person that you're really not sure of and you're fine with either way, then go ahead and poke that bear and get the assessment. But if you're worried, just get some good legal advice about how to get the role characterized and functioning in a way that's consistent with each other. Phil, anything to add on practical tips here?
Yeah, as I always say, proactivity will win the day. A pound, an ounce of prevention is worth a pound of cure every time. And I know it can be tricky, especially when establishing a new business entity. You have 75 pieces moving at once, and the nuances of your CFO's independent contractor relationship is like number 19 on the priority list, right?
Yeah.
Like I get it. Like I totally get it.
Right? On that list. It's
right?
not even on the list.
Yeah, it's not even on the list, right? And that's fine, right? But hopefully, maybe one day it makes it on the list, and you give it a few hours of time, and in the long run, it saves you an immense amount of headache. So.
Yeah, exactly. We've answered a bunch of questions, so we will. We don't have time for more, unfortunately. One of the questions was, is there a list of these independent contractor criteria? And so reach out to us. We can give you a hand on that. It's not just a pure list. It's really a legal analysis. And I'm not trying to upsell people. I think there is legal nuance and tons of case law on all of this. So we do contractor classification audits all the time. So feel free to reach out if you need a hand with that. And I think that pretty much wraps up our webinar for today. So thank you to everyone for joining us. Our next session is going to be on April 16. We do this on the third Wednesday of the month, 10:30 in the morning EST. The next session is going to be on performance management in the remote and hybrid work environment. So it's sort of putting two things in together, the performance management and how do you do that remotely, so managing your remote workforce. We're all becoming experts post-COVID, but how do you deal with discipline and termination type issues as we go along? If you have any follow-up questions, please feel free. I love that people are using the React buttons. You can see that the platform has finally updated and is not looking like it's 1993 anymore. We're very happy. So thank you, everybody.
Love it.
Feel free to ask any other questions after the fact. Come to our website at springlaw.ca, follow us on social, sign up for our newsletter, do all the things. We'll keep you updated. And we will see you next month at the next webinar.
Thanks so much, everyone. It was lovely being here, and hopefully chat again soon, okay?